Hello, everyone, and welcome to our Young Europeans Network and EU Delegation webinar on the EU settlement scheme. I'm Alexandra Bulat. I'm the co-chair of the Young Europeans Network at the 3million. And today we will be taking questions from you on the EU settlement scheme. A lot of you are still yet to apply. Maybe some of you applied for settled and pre-settled status and still have some questions about your rights in the UK. Just a few words about the Young Europeans Network before we start with the substance of the webinar today, which is the EU settlement scheme. We are a volunteer led group within the 3million. We're about 14 regular volunteers who campaign on citizens' rights, ranging from EU students' rights, citizenship campaign, voting rights, and we often organize some informative events for everyone, really, for EU citizens, their families, and their friends to be more informed on issues such as the EU settlement scheme, citizenship, and other issues of interest for Europeans in the UK. Some of my colleagues from the Young Europeans Network, some of the volunteers will be present on the chats on Zoom to post useful information and links. And today this event is in collaboration with the EU Delegation in the UK, and we have Chris Benn from Seraphus and the EU Delegation, who is an immigration lawyer who will be answering some of your questions and giving an overview of some of the issues about the EU settlement scheme. A bit of housekeeping before we start this webinar. So we have people on Zoom here. Someone asks whether the webinar will be recorded. So the webinar is also on the Facebook Live, the 3million Facebook Live page, and the video will be later posted on our YouTube channel. So if you signed up via Zoom, you'll get a follow-up email in a couple of days with the recording, with the link to Facebook and the YouTube, the live streams. So you'll be able to rewatch the video after. And if you're on Facebook watching the live, the video will be saved on our page after, so you can keep the link and watch it later on. So for those of you on Zoom, you have a couple of options here. So you have the Q&A button, the Q&A chat here, where you are able to put your questions for Chris in the Q&A session, part of this session. And then you have also the general chat on the right hand side, where you'll be able to hear from some of our volunteers, have useful links, and also feel free to say hello, introduce yourselves, and like say other comments that are not necessarily a question but you want to communicate to us. So that's kind of just the housekeeping. And if you are on Facebook as well, I can see your comments under the Facebook Live, so you can add your comments on the Facebook live stream as well, and questions. And again, we'll collect a few of those questions in the Q&A session. So I hope you enjoyed this webinar and you find a lot of useful information and advice. And before I introduce the program for today, I just want to say it's really important that now a few weeks to go until the end of the transition period, which is the 31st of December 2020. It's really important we inform our EU citizens, friends, colleagues, and neighbors about the EU settlement scheme, about their rights in the UK. Of course, the deadline to apply to the EU settlement scheme is the 30th of June 2021, but people do need to be in the country, in the UK, before this end of transition, 31st of December 2020. And it's very important we have information not only on how to apply, but actually what rights we have with the different types of status, how to prove our status later on, and many, many other questions, which I'm sure will come up in the Q&A event. So the program for today would hear from two of our young European volunteers. First, James, here with us today, will explain a bit about the context behind the latest EU settlement scheme statistics and provide some comments based on his research on this issue as well. And then we have Maria, who will present a student perspective in terms of like outreach, how informed are students about the EU settlement scheme and what can be done more. And after those 10 minutes of brief interventions from our volunteers, we will have a presentation from Chris about the EU settlement scheme based on some of the questions you asked in advance. I think we had over 30 questions submitted on Zoom in advance. So some of those questions, if you ask the question in advance, will be covered by some of the points in Chris's presentation. But then afterwards, if your question wasn't answered or if you have additional questions, feel free to use the Q&A chat, and I will then collect questions from both Facebook and Zoom. So that's it from my side. So I will hand over to James now to tell you a bit more about the EU settlement scheme data and the context behind those big Home Office numbers. So over to you, James.
Okay, hi, nice to see you all. I'm James and I'm a volunteer with the Young Europeans Network, as Alexandra said. So I'm going to share a couple slides that show some of the Home Office numbers. If I can figure this out. So is this visible?
Not yet, no.
Oh, no. Maybe now?
Yes, it is. That's fine now.
Yeah. Okay, perfect. So here are some headlines from the Daily Mail showing these like grand Home Office numbers, how many people have applied to the settlement scheme. And I want to kind of talk about these in detail, like one, like how optimistic this is, but also kind of some of the challenges that you still face with this. So where is this? I'm looking at my notes here. Yeah, so one, it's the fact that you have almost 4.5 million people applying to this. It's like a testament to the fact that the Home Office and charities like the 3 million have done a pretty good job at getting people to sign up. It's a challenging scheme because it means that the way that it's designed, I mean, everyone who wants to stay here has to actively register. So this high number is on one hand a very good thing. But on the other hand, I kind of want to go in and say that a problem we have is that we actually don't know how many people this 4.5 or so million covers. So this here is a chart that I made by taking several nationalities and subtracting the number of applications from the total population for this demographic on the annual population survey. And what you see on the left here is that a lot of demographics, you have more applications than people living in the country. And so that tells us a couple things. First off, where is this? The population data we have for the UK is not very good. So this is from the annual population survey, which doesn't count people living in communal establishments, people who come here and live in overcrowded housing or with friends, or some people in student accommodation. And a lot of the Home Office numbers in terms of how many people actually are living in the country from the EU are just very, very bad. Passenger surveys and censuses just don't really cover a lot of folks, especially people who really don't want to be counted. And whereas the EUSS is going to register basically anyone who finds out about it and meets the qualifications and can apply. And so population data you have just doesn't capture a lot of the people who are going to be most vulnerable to not registering in the first place. So seasonal laborers, very poor people, and these are the ones that you really want to ensure that they find out about the scheme and can apply. So there's a very big issue with data quality here. And we don't really know what share of the population 4.2 million actually represents. So that could be, how do you say, we really don't know how many more people we need to get to sign up before we ensure that everyone who needs to sign up actually does. And so on the next slide, this is a list of people that, groups like the 3 million, like Citizens' Rights Project, have looked at and have kind of found some evidence that they may in the future, but definitely are now, having issues signing up for the EU settlement scheme. So young people, especially people 18 or 21 years or younger, may simply not have evidence, or they may be dependent on their parents to apply. A lot of the folks here simply don't have control over their ID documents. A lot of these people are not going to be necessarily linked into British newspapers, or they may be hard for charities to reach. So while the, do you go back? Up? Oh yeah. So the 4.5 almost million people is a lot. It kind of doesn't mean that we've reached everyone that we need to. So I think, am I at my 5 minutes?
Yes, that's perfect.
Oh, perfect, great, thank you.
Well, thank you very much, James. So this is just a bit about the numbers and the context behind the numbers for those of you who don't avidly follow the Home Office statistics like I do. And now we hear an experience from the ground from one of our volunteers, Maria, who works a lot with student communities and has a lot of stories from students speaking about their awareness or lack of awareness about the scheme. So Maria, over to you.
Thank you, Alexandra, and thank you for having me. Yeah, I wanted to come in and bring in a perspective as an EU citizen living in the UK and as an EU student who recently graduated from a UK university. So yeah, firstly, some background about myself. I have lived and studied in the UK for 4 years now, and I'm currently looking for a job here. I applied and was granted pre-settled status about a year ago. And in about another year, I can reapply and receive settled status. Now, from my experience as someone who has had multiple part-time jobs and has been a full-time student at 2 different institutions in the UK, I personally, from my experience, was not made aware about how important applying for settlement is. I was not told about what the repercussions of not applying would be. The only reason I was informed about it was really because I studied politics and was naturally following the Brexit debate and the developments around it. And through my experience as a student and being a student representative and generally just having friends who spoke about this, I've seen that many other EU students were just not aware or were misinformed about what the scheme was and who needs to apply. Sure, many of them kind of had heard about it, but very few knew whether they fit in the category of people who should apply. And they didn't know that those who didn't apply would lose access to a lot of their rights and privileges that they've just been used to having as an EU citizen in the UK. And I think that this doesn't just apply to students. I think this very much applies to all EU citizens in the UK. I know of so many people who have had the misassumption that having permanent residence in the UK is enough and that they don't need to apply for settlement because they're safe, because they've already had this previous status, so they don't need to reapply for a new one, or of employers who are unsure of how kind of the end of the transition period would affect their hiring of new employees, all that stuff. And I think it's because of this lack of awareness that events like this one are important and useful. We often expect our universities and our employers to kind of answer all those questions and inform us on time about these developments, but unfortunately, from my experience, this hasn't necessarily been the case. A lot of them are very wary and are scared to give any sort of kind of legal information. So it does often just come down to us researching and accessing all this information ourselves. But yes, I don't want to take any more time from the Q&A, so I'm gonna stop here and hand over to Chris.
Thank you very much, Maria. It's always good to have a perspective from, especially from the student community, and I think it's yes, it's important to underline that the job is not over yet in terms of outreach and information of EU citizens in the UK. There's a lot more to be done, especially with groups more at risk. Before I hand over to Chris, we'll first of all do a presentation answering some of your pre-submitted questions through Zoom, and then we'll go to the live. I just want to do a very quick poll here just to see who our audience is today on Zoom. Sorry for those on Facebook Live, you can't see this poll. So just looking at like whether you're a British citizen just here wanting to inform your EU friends, whether you already applied and have either settled or pre-settled status, and whether you still have to apply for the settlement scheme but haven't done so yet, in which case obviously this webinar is specifically for you and your questions, but often we attend those events to inform others, and I will encourage everyone to actually inform others in their community, EU citizens in their community about this. So yes, let's see who voted. Yeah, that's very, very interesting. Actually, most of the people here have status, either British settled or pre-settled status, but perhaps you have questions about your rights with the status. And yeah, quite a few people haven't applied yet. So I really hope that you will find the information you need today. So without further ado, I'll hand over to Chris now, who'll do the presentation covering your questions. And if during this presentation you have other questions, use the Q&A chat. And then after this, we'll go back to the Q&A chat and collect some questions from Facebook Live as well, and try to get as many questions as we can until 6 p.m. So yes, Chris, over to you.
Thank you very much, Alexandra, and good evening to everyone who's joined. It's very nice to be able to speak to you this evening. So just a brief and quick introduction about myself. My name is Chris Benn. I'm an immigration lawyer with a firm called Seraphus, and we work with the European Delegation, providing advice about the EU settlement scheme. And part of the work that we do with the delegation is to come out and try to, well, in the past it was physically come out and talk to people, but nowadays, of course, it's mostly on online platforms. But the idea is still the same, which is to make sure people are informed about their rights and what is expected of them by the UK government, moving from the transition period into the grace period after the sort of some of the Brexit process concludes. So that's what I'm going to talk about in my presentation. I've tried to base the information in the presentation on the questions that I've received in advance to try and focus it on what I think people want to hear about. It's probably going to run a little bit longer than I'd initially anticipated, because some of the questions that I'm being asked about absences from the UK is actually a very complicated area. So I wanted to give it the right amount of time to make sure people sort of understood which situation applies to them. And a couple of the questions that have already come in the Q&A box are tied into that, which is why I've said that I'll deal with them live. So I'm just going to go to my presentation now, and I'm more than happy to circulate this after the session to anyone. Because of some of it, I'll have to fly through a little bit quickly. Obviously, I saw in the poll that people do have settled status or pre-settled status. There are some people left to apply, but just to obviously give the information that I'm sure you do know, which is that you get settled status in most situations if you have been here for more than 5 years, and if you've been here less than 5 years, you will be applying for pre-settled status, and then you'll be expected to make a second application to get settled status in the future once you've got those 5 years. We have two deadlines, which is obviously not ideal. One is to have a residency deadline, which is the 31st of December 2020, so the end of the transition period with the EU. And that is because everyone has to be resident before that date to qualify under the settlement scheme, unless you're a family member who's being sponsored to join later on, and I'll come back to that. But the idea is that everyone who is resident in the UK before that date is eligible to apply to the scheme, and I'll come back to what does being resident mean in a little bit. And then you have the application deadline, which is 6 months after the residency deadline. And so that's the firm date that the Home Office has given everyone to apply. And obviously what we want is to make sure that everyone who is covered does get their application in time, so that they don't face the difficult consequences of not having an application and becoming unlawfully resident in the UK, because it's a very serious outcome for someone. So that's the main purpose of the outreach work, and of course we're hoping that everyone who joins this evening will be able to spread that word as well. So what does how do you prove your residence? And the reason I've included this is because I've had some questions come in about national insurance numbers and comprehensive sickness insurance. So I thought I'd just clarify really what you need to do to prove your residence. Now, the settlement scheme is based on residency. It is not based on exercising your European free movement rights. The withdrawal agreement with the EU is about free movement rights, but the settlement scheme is wider in its scope than that. And so it just requires EU citizens, including, of course, EEA citizens and Swiss citizens. I'm going to refer to EU citizens because that's just the shorthand way of doing it. But it just requires you to be here before that cut-off residency deadline. So you don't have to be economically active. And particularly for anyone who's applying as a student, you are not required to hold comprehensive sickness insurance to qualify. Okay. CSI has an impact on British nationality, which I'll come back to, but it does not matter as far as the settlement scheme is concerned. When you apply to the scheme, you will be asked for your national insurance number because the process carries out some automatic checks on a national insurance number to see if it can see the person's like tax national insurance records as being active, because that's an indication that someone is resident in the UK. A question that came in was, do I need to have a national insurance number to apply? And the answer is no, you don't need one, because it is about residency. Having a national insurance number is helpful, but it's not a prerequisite to applying. So if you don't have a national insurance number, what will happen is you will just continue through the process, and it will ask you to upload a scanned copy of whatever residency material you can produce to show that you are in the UK. So that's why the difference between having a national insurance number and not having one will impact on the application. It's just about how the process checks that you're here. And so that's the way in which you'll make your application, and it will very much depend on what type of residency evidence do you have to show that you're here, to what you'll upload. Again, someone submitted a question about is something like a letter from your university sufficient evidence of residency, and the answer to that is yes, it should be, because your university can say, well, this person's been studying between 2018 and 2020, and that will be information about you being resident here. So that's something that can be used. Now, there's a link at the end of this presentation to the Home Office guidance on residency evidence. And just to bear in mind, it is guidance. It is not the only thing that they will accept. They cannot say it has to be evidence in this format. They have to look at everyone's evidence to make sure that you're given as much opportunity to prove your situation as possible. So that's what we have with the documents. So just want to cover the differences between pre-settled and settled more because it helps understand the absences criteria. So what we have pre-settled status is limited for 5 years in every single case. Doesn't matter how long you've been here. If you're getting pre-settled status, you'll be given 5 years of limited leave to remain. During those 5 years, you're expected to apply for settled status, and you can apply for settled status as soon as you have enough evidence to show you've been in the UK for 5 years. You don't have to wait until the end of your pre-settled status to make your second application. Whilst you're in your pre-settled status period, those 5 years of qualifying for settled status, you are bound by what is called the continuous residency rules, which I'm going to come back to because they're complicated and they have been made more complicated by COVID, unfortunately. And a lot of the questions that I received were basically about the impact on this continuous residence. You can lose the status if you commit a criminal offence. That's the same with any UK immigration status, but that's just something that would happen. If you get settled status, so obviously if you've already got the 5 years of qualifying, that's what you want to be applying for. It's called indefinite leave to remain, and as the indefinite indicates, it is your permanent right to live in the UK. It's subject to very limited conditions, which is essentially it's the same criminal offences condition, but really the one that people need to be aware of is the absences criteria, which is once you've got settled status, you can be absent from the UK for up to 5 years without losing your status. So what that means is if you left today, you have up until 5 years in the future to come back into the UK before you would lose your status. And it means, like, if you didn't step foot on UK soil for 5 years, you would lose your status. So it's quite a long period of time you can be away for. And that's important, because for those people who submitted questions about, oh, I have settled status, can I go away over Christmas? Obviously the answer is yes, because as long as you're not away for Christmas and then another 5 years after Christmas, you're going to keep your status. And that question about Christmas, it does apply to those with pre-settled status as well, except that you have a more limited period of time when you can be away for, which I'll come back to in a second. Another question that was submitted in terms of coming back to the UK was about, do I need a visa to come back to the UK? So that might be someone who has pre-settled status, settled status, or it might be someone who's yet to apply, who will make sure that they will apply before the 30th of June. And in all cases, anyone leaving for Christmas is not required to have a visa to come back into the UK. So if you haven't had your status granted yet, don't worry, you'll be able to come back into the UK in 2021. There's not going to be you won't have to prove that you've been living here when you come back into the UK. That's not what's going to happen. After the 30th of June next year, quite possibly you will be asked for an immigration status at the port of entry, but not in the first 6 months of 2021. It's not supposed to happen like that. So essentially the point there with settled status is it's much more secure because you've already done your 5 years of qualifying. We'll come back to British nationality again, because I had questions about it, but once you get settled status, you can progress through to British nationality if you meet the other conditions for that. I've been asked about family members. So it's important to know that when you are a principal status holder under the scheme, so when you are someone who qualifies for pre-settled or settled status, you have family reunion rights. And the rights are the same. It doesn't make a difference to you which status you hold. You have those family reunion rights. And that is to sponsor people who do not live in the UK with you at the moment. And the family members who you can sponsor are essentially, they're set out in those 3 sub-bullet points. They're spouse, civil partner, a durable partner, I'll explain in a minute, children, grandchildren, dependent parents, dependent grandparents. Now, the key to understanding whether or not your family member can be sponsored under the settlement scheme is, when did the relationship begin? And really this applies to relationships, because if it's your parents, your relationship's already there. If it's children, they're either born already, or if they're born in the future, they're still covered by the scheme. But for those relationships that we have, which is the spouse, the civil partner, the unmarried durable partner, that relationship has to exist before the 31st of December 2020. So you need to be married before that date, you need to be in a civil partnership before that date, or you need to be accepted as being in a durable relationship before that date. And what that means is that your relationship is considered serious. The Home Office has a broad definition, which they say, well, if you've lived together with someone for 2 years, we accept that as being serious. But that's not the end of the matter. European law does not prescribe how you have a durable, serious relationship with someone. So people who've lived together less than 2 years may still qualify if they can show the Home Office that they're in a serious relationship. It's quite a complex area, but the general rule is that when you're applying as a durable partner, you have to show as much as you can to show that your relationship is serious and it's not someone that you started dating last week, for example. So it's a bit of a complex area, but the rule is always the same. If the relationship exists before the end of the transition period, it's covered by the settlement scheme, so you can sponsor that person for free to come and live with you. If you got married on the 1st of January 2021 or got married further on any year in the future, your relationship isn't necessarily covered because your marriage comes too late. And what that means is that if you wanted to sponsor your spouse to come and live with you in the UK, you're under UK immigration rules at that point. And someone's asked about does that mean I have to earn £18,600 to sponsor them? And the answer is yes, that's the rule, because it's the same rule that applies to British citizens. So it's a lot more complicated. They also have to have an English language qualification. You have to have somewhere to live that you can prove that it wouldn't be overcrowded, and the visa application process is expensive. So it's not ideal in that situation, but it will apply for people who get married after the end of the transition period. The only thing to say about that is if someone gets married after the end of the transition period, they might still have had a durable relationship before the end of the transition period. So that's something that would need to be investigated. But that's the rule on joining family members. Okay. So really, a lot of the questions, and probably most of the questions I had, were about what's a continuous, what does being absent from the UK mean? How does this affect me? And this is, so now we're talking at people who have pre-settled status, not settled status because you've got your 5-year absence, so pre-settled status. So that your qualifying period begins once you enter the UK. So that's when it starts. And the idea is that you build up 5 years of continuous qualifying, and then you can qualify for settled status. So during those 5 years, you have to maintain this continuous qualifying residence. And I've just put down the bottom there that don't worry, you won't break your continuous qualifying residence if you go home for Christmas. That's not going to happen, and you don't need that visa to return. But being continuously resident means the following. So if in every 12-month period, if you looked at it, you need to be in the UK at least 6 months. So simply put, if you come to the UK on the 1st of January, if you take the 1st of January to the 31st of December, if you're in the UK for over 6 months, over 183 days in that period, then you would be considered to be resident. But if you took a break, if you came in January and then you left for 7 months and then came back after those 7 months, you've broken your continuous residence. Okay. And also just to note that if you have 2 periods that add up to more than 6 months absence, then you're also breaking your continuous residence. So a 3-month absence combined with a 4-month absence, let's say, in a 12-month period, adds up to 7 months, breaks the residency. So it's really important to look at your situation and understand if that's happened, because of COVID, more people are in this situation. Now, there is also a clause in there that says if within your 5 years of qualifying for settled status, you are allowed 1 period where you can be outside the UK for more than 6 months if it's less than 12 months and it's for an important reason. Now, the important reasons are listed in the rules as those ones that I've put in those subparagraphs. So for a lot of people studying, for example, may well be on this call, might be studying, you can do a year overseas or up to a year overseas as part of your UK university course without breaking your continuous residence. So if you do 2 years at university, go abroad for a year, come back, and then do another 2 years in the UK, adding up to 5 years, then you've met your continuous residence requirements for settled status. Okay, so that's important to note, because it will affect lots of people who are studying. And this is where COVID-19 has had such a dramatic impact, because the question that I often get asked is, well, I've actually been outside for more than 6 months, and it's because I had to leave because of COVID. Maybe my university education moved online. Is that an important reason to be outside the UK for more than 6 months? Now, I would like to say to almost everyone that the answer is yes, but I think we do have to be a bit more cautious than that when we talk about it as immigration lawyers, because there isn't been a universal declaration by the Home Office that COVID is always going to be accepted as a reason to be absent for more than 6 months. They have said in some situations that they will accept it, but they tend to talk in terms of travel and being like not being able to leave or return to the UK because of restrictions, which is much more of a kind of forced situation than someone saying, well, actually, look, my university just told me to be abroad and they didn't want me to come back in, and because of the, spreading the virus in the halls of residence or so on. So we don't really know to what extent this COVID policy will cover everyone who's been absent for more than 6 months. So you do have to approach it quite cautiously. The Home Office has said they will produce some guidance on it, but at the moment it doesn't exist. So we can't really give you that advice as someone who sort of acts as a lawyer and wants to give people clarity. I've put in a couple of things down the bottom, which is important to be aware of, which is one, if you've already had an absence that exceeded 6 months, maybe for studying in a year beforehand, and then you've now got a second period where you're absent for more than 6 months, you can't do that because you'd have 2 periods that exceed 6 months. And as you saw from the previous slide, that isn't allowed. So in that situation, you will have broken your continuous residence and you need to take action, which I'll come to in a minute. There is, other than military service or working for the UK government, you're never allowed a period outside the UK of more than 12 months. And if you have more than 12 months, you break your continuous residence. So again, if you said I left in February because of COVID, and if you didn't come back until March 2021, you've exceeded the 12 months and you've broken your continuous residence. So always be aware that there is a 12-month maximum on this rule as it stands today. if you think you've broken your continuous qualifying residence, so if you said to yourself, right now, I've been outside for more than 12 months, so I've definitely broken my continuous residence, what do you need to do? Well, you need to be back in the UK before the 31st of December is the answer, because you need to begin a new qualifying residence. You need to start those 5 years again. But because you cannot start a new qualifying period after the 31st of December 2020, there's a lot of pressure to resume your residence before that date. This is why people really need to look at their situations to understand whether or not that may apply to them. If you don't do that, then even if you've been granted pre-settled status, you're going to have a problem qualifying for settled status in the future. And the reason for that is because you'll see in the Home Office letter that grants you the status that they allow you up to 2 years outside the UK without losing your pre-settled status. It's written in every single grant letter. You can see my views on this is the last bullet point down the bottom, which is ignore that particular clause, because technically and legally speaking, it is true. You do not lose your pre-settled status unless you exceed 2 years outside the UK. But because of those continuous residence rules, because of that 6 month in any 12-month rule where you have to be resident, if you are outside the UK for 18 months, you will not lose your pre-settled status, but you're not going to be able to convert that pre-settled status into settled status in the future. So that's your problem, is you get to the end of the 5 years of pre-settled status and then you try to get settled status and they say, well, have you had any absences of more than 6 months in a 12-month period? And you say, well, yeah, I was outside for 18 months because I'm allowed up to 2 years. And they'll say, oh yeah, you are allowed up to 2 years, but you can't qualify for settled status now. So that's the end of your visa. So it's a really, I mean, it's legally speaking, it's correct, the 2 years, but it's misleading to imply that someone should be outside for up to 2 years and there's not going to be any impact on their future. There will be. And so it's a real kind of issue I have. I know people who will contact the Settlement Resolution Centre and they'll be told that information about the 2 years, but it's massively misleading in terms of your futures. So just disregard it. You have to work with that 6 month in any 12-month period. Okay. Students who are not in the UK, who started their courses in like autumn this year, haven't been able to move to the UK because of online courses, being advised, no, don't come. It's not, we don't want you to at the moment, join next year. How does that impact on you? Well, you need to begin your qualifying residence before the 31st of December, even if your university is advising you not to move to the UK, because they're not advising you about the settlement scheme, they're advising you about the health risks. And so there is a real problem if people do not move to the UK who've never had a presence here before, then they're not going to qualify under the settlement scheme. And that's going to cause an impact in how do I carry on studying in the future, because you're then subject to the new immigration system in the future, which involves paying for student visas and the NHS health charge. So it's a really dramatic impact on you if you don't meet the residency rule to be here before the 31st of December. What does people, and again, it's come up in the questions, what does being resident before the 31st of December mean? Well, it can mean an incredibly short period of time, actually. The idea is that anyone who is physically in the UK before the 31st, before 11 p.m. on the 31st of December 2020, is covered by the withdrawal agreement and is covered by the EU settlement scheme. And what that means is you can come for a short period before the end of this year, and you can leave again. And as long as you come back within those 6 months that you're allowed outside, and as long as you meet the application deadline of the 30th of June 2021, you should qualify for pre-settled status. That is how the system is supposed to operate. So people have said, oh, if I have an Airbnb receipt over 31st to the 1st of January, I've got an Airbnb receipt, I've got like a travel ticket showing I arrived on the 31st. Is that enough? The answer is it should be. What we don't know yet is how the Home Office will process these types of applications, because we always have the worry that there isn't the right consistency with the decision making, but the conditions are met, and that's the important thing. Okay, so you can have a very short period of residence before the end of this year, and that will qualify you for pre-settled status. Okay, so that's important. Right, I'm going to finish up. I know I'm sort of probably running over my time, and I'm just trying to cover so much. I'll just talk about British citizenship because, again, it's things I've been asked about in advance. So children, the first thing I will always want to say about children is, unless they hold a British passport in their hand today, then you need to think about whether or not they need to apply to the EU settlement scheme, and start your assumption with yes, they do. And then if you move away from that assumption, then that's fine. So you assume they need to apply, but they do not need to apply if they are Irish or if they hold indefinite leave to remain in another immigration category, which may occur. So in those two situations, they can apply to the scheme, but they're not required to, because they already have the right to live in the UK. If your child does hold that British passport, then it doesn't, if they're British or if they're dual British EU, then they cannot apply to the scheme. They cannot have an immigration status under the scheme because they do not need one. Their passport is everything that they need to live in the UK. Some children are not British at the moment, but they may apply to become British in the future. That's absolutely fine. Their EU settled status or pre-settled status will fall away if they become British, but until they become British, they would need to apply under the scheme. Are children born in the UK British automatically? Sometimes is the answer. It's not a clear yes or no. Some children born in the UK are, some children aren't. It always depends on the status of the parents when the children are born as to whether or not the child is British. Again, this is why you always need to check with those children. If you haven't got a passport for them already, then you don't know that they're British. If you're confident that your child is born British, you apply for a passport from the passport office, and they will issue you one if they agree with you that the conditions are met. If your child is born in the UK and they're not British, I mean, for example, if the parents have been in the UK for a couple of years and then they have a child, that child is not going to be born British unless one of the parents is British, and therefore the child would have to apply to the EU settlement scheme. Children who are born outside the UK are very rarely born British without having a British parent. Okay, so if you brought your children to the UK, they're unlikely to be British. So if the child is not British, then you need to, you either need to apply for them to the EU settlement scheme, or you need to establish whether they can register as a British citizen, because as I say, children can become British at a later, even if they're not born British. For example, if you have a child who's born in the UK and the parent gets settled status, the child, if they're not born British, can then register to become a British citizen. It costs £1,012, so it's not a cheap application, but it's an option to that child. But they don't have to register to become British. It's a choice to become British. And if you don't do that, then you need to apply into the EU settlement scheme. Every time you're addressing a situation with someone becoming British, you always need to think about the impact on that person's nationality, because some countries do not accept dual nationality. And therefore, if you become British, you'll lose that nationality, and you would want to think very carefully before you lost an EU nationality to become British. I would imagine that's something to think about very carefully. British citizenship doesn't mind people having dual nationality, so there's no impact from the British side, but there is an impact sometimes on the original nationality that the person holds. Someone asked me a question about becoming British in 2021 as a German citizen. So I can tell you from the British side, there's no issue, because British citizenship doesn't mind if you have dual nationality. I can also tell you from a German perspective, without being an expert in German law, that in principle, they may have an issue, because normally German nationality needs to be with another EU country, of which the UK is no longer. So, but you need to check your position with a German nationality lawyer, but the British side doesn't matter. So think about, this is what you need to think about for children, is the child needs to be in one of these situations by the end, or by the 30th of June 2021. They either need to hold a British passport or be British, be registered as British, again, going through the process and holding a passport. If they're Irish, that's fine. Or if they're holding indefinite leave to remain already, that's fine. And if none of those apply, they need to hold status under, or they need to apply for status under the scheme before the deadline, okay? Adults, it's a little bit different. If you obviously you'll know if you're born British or not born British. I'm assuming most people aren't. You can become British if you hold settled status. You cannot become British if you hold pre-settled status only. As if you're over 18, you need to be permanently resident in the UK. There's different conditions to becoming British. different residency. It also costs over £1,350 to naturalise, because you have to pay for the life in the UK test, so it's very expensive. And this is where that comprehensive sickness insurance issue arises, because when you apply for British nationality, at the moment, the rule of the Home Office is they look back over your residence in the UK for quite a long period, up to 10 years in some cases, and they will want to see if you were a student or if you were not economically active. They would want to see that you held comprehensive sickness insurance, which can be a European health insurance card. That's not a problem, but they will ask you about that, and it may cause a problem. There's a discretion to allow people to apply even if they didn't have health insurance when they were supposed to, but the guidance is not very clear on this point. So it is something to check. I mean, anyone thinking of naturalizing, do check with someone who's qualified about whether or not your situation meets that criteria, because obviously you lose the money. You wouldn't lose your settled status or anything like that, but you would lose your money if you applied when you weren't able to. And also the family reunion rights that I talked about earlier, about those sponsoring family members, they may not apply to you if you become British in the future, because you have to meet the conditions of a European case law, which is a little bit more complicated. So there's something to think about. Final point there as well, check your own nationality, or check your initial nationality, because you wouldn't want to lose it. Okay, I'm going to finish there. Just on those slides which will circulate, there is information about people to help apply, the Home Office Resolution Centre, some publications, and then there's all this Home Office guidance. The one I was talking about, which is the evidence of residence, that tells you what type of documents the Home Office likes you to present when you make your application. So thank you for listening to that. I'm sorry it was a very, very quick effort. I speak very quickly when I need to get through lots of information, but hopefully I can see there's lots and lots of questions. I'll stop sharing at this point. I know we overran slightly on that one. I'm very sorry. I hope that I was just trying to cover as much as possible.
That was great, Chris. Thank you very much. I know how difficult it is to go through all the different topics. We received about 30 questions ranging from child citizenship to pre-settlements, pre-settled status to absences. So I think you covered a lot of those questions. I think we'll have, because we have about like 50 minutes left, but maybe we'll have like 20 minutes for a few questions.
Yeah. No, I mean, I'm not. It's my fault, so I will stay as long as we want to stay to work through this. So please,
not too late, but maybe a few questions in 20 minutes or so. I see you already had some that you said you'll answer on the chat, so I'll read those out first, and then we'll go through some of the Facebook ones as well. Sure. Just before we start the Q&A, because a lot of people asked about the recording. So if you're following on Facebook, you can rewatch the video after. If you registered on Zoom with your email, like if you're on the Zoom in the Zoom room now, I will follow up via an email with you with the recording on YouTube, a video recording of this session, and also the slides from Chris that Chris will send us after this presentation. So if you're on Facebook and watching this and you want to be added in the email list and get the slides as well, please do email ye@the3million.org.uk, and the volunteers will be able to add you to that and make sure you receive the slides as well. And perhaps someone who is following the live stream can put this on this email address in the comments as well. We have a lot of questions here, so I see like 28 open questions. So maybe let's start with this one from Ahmed, who says, I'm a bit worried for my son. He earns almost £18,000 annual, and next year he'll get married to a Pakistani national and would like to bring her here in the UK. Is it straightforward, or does he must earn 25,000 a year to bring his wife? So I see you mark this, Chris, that you're going to
answer. Yeah, I mean, I think that one hopefully was covered. As I said, if you're applying under those if you're applying for someone who gets married after the 31st of December, there is a rule that says the sponsor has to earn 18,600 in order for them to bring their spouse to the UK. I don't know where 25,000 came from. That's not right, unless you're including some children in that. But the main figure is 18,600. If you're not eligible for the family reunion under the EU settlement scheme.
Okay, thank you for that clarification, Chris. I see some debate in one of the questions about access to welfare for those who have pre-settled status, someone saying that you cannot actually get welfare benefits, you have pre-settled. Could you please maybe clarify the entitlements for welfare pre-settled compared to settled?
Yeah, I mean, essentially, what's happened with pre-settled status is that the current situation would be that if you're an EU citizen in the UK and you're applying for benefits, they will ask you to prove that you meet a habitual residence test. Part of that test is about what's called the right to reside. If you have settled status, then you pass the right to reside automatically because you're indefinitely resident here. If you have pre-settled status, they will ask you to show that you've been exercising your free movement rights, i.e. that you've been economically active before you needed to claim benefits. And what that means essentially is that some citizens with pre-settled status will qualify for benefits and some citizens with pre-settled status won't qualify for benefits. It depends on what your situation was before you needed to make the application. So the Citizens Advice website has a good section on how an EU citizen has to meet the right to the reside test. So I would encourage people to look at that. But the answer is, just because you have pre-settled status doesn't mean that you won't have access to benefits, but you are going to be asked to prove what your situation was or is at the point when you apply for them.
Thank you for that clarification. I think there's one quicker fire round questions.
Go for it.
Richard here asks, if I arrive at the end of December, should I wait to apply for pre-settled status or apply immediately once I arrive?
It doesn't make any difference because you've got to apply before the 30th of June 2021. So I would say you should apply when you have the evidence that you can use to show that you're here before the 31st of December. So if you're using your travel ticket into the UK, you'll have that on the day you arrive. If you want to wait and get a hotel bill, an Airbnb bill to apply with, then you can wait a few weeks or something. So essentially just apply when you've got the evidence to do so. It's probably better to get your status sorted as quickly as possible because then you know that you're safe. But it doesn't make any difference in theory as long as you meet that 30th of June 2021 deadline.
Okay, going on to the next one, a question from Facebook this time. Question regarding non-EU family members who are in the UK and have a biometric residency card under EU regulations. What's the deadline for them to apply for settled status?
So a family member who holds a biometric residence card, the same deadline applies to them. It would be the 30th of June 2021. I have to put in a little lawyer's kind of caveat here to say that if they are what's considered an extended family member, then actually they will need to apply before their biometric residence card expires. But that's if they fall into the extended family member category. But if we're talking about someone who's like a spouse or a child, something like that, 30th of June 2021 is the deadline to apply, like the main EU citizen would be.
Okay, and next, going to the quick fire round questions. I always like those in the Q&A. Another one from Facebook. I started my university course in the UK last year in October, but I'm now in Belgium since March, studying online because of COVID. Presumably, they haven't applied yet. So can I still apply for the EU settlement scheme? What should I do in my case?
Yeah, I mean, that is exactly one of those situations where I was covering with the continuous residence, where you're outside the UK for more than 6 months. So you need for the Home Office to agree that it's for an important reason, which of course you all say is COVID, and I would certainly agree with you from my perspective, but we have to look at the Home Office perspective, unfortunately, here, which sometimes doesn't always agree with what we think. So when you apply from outside the UK, and you're applying for pre-settled status, normally what will happen is if you put in a document that shows you were here in February 2020, then the Home Office will come back to you and say, we need a document in the last 6 months, because otherwise we think you've left for more than 6 months. Now, my position on that is that if you're in that extended period for more than 6 months but less than 12, then if you can show that that to the Home Office, then they should still grant you pre-settled status. But it is a more complicated process, unfortunately, because you're asking them to assess whether or not your reason for being absent is for one of those important reasons, because you've been outside for more than 6 months. So it's definitely not straightforward. And of course, the problem that you have is if they say, no, we don't think that your particular situation is one, even though it's COVID related, but you weren't forced to be away. And that's where we have this worry about what's the interpretation. Then they might say, well, actually, you've broken your continuous residence, and so you need to begin a residency before the 31st of December. So in your situation, on the 9th of December, I would apply now as soon as possible and explain. You'll be asked to upload documents about your residence, and I would put a letter in saying, I've been outside for more than 6 months. I recognize that. But it's for an important reason. So I know I won't be outside for more than 12 months. I mean, that's the only way to apply from overseas in your situation. The alternative is to come back in and then apply with residence that you came back in before the 31st of December. So it's a very difficult situation in there, and it's not straightforward for you, I'm afraid.
Okay, thanks, Chris. Still 29 to go. The questions are multiplying as we answer, but we'll carry on for like 10 more minutes.
Quick fire is fine. It's okay.
Yeah. Can my dependent non-EA parents apply for a visitor visa? Presumably this question is referring to the system after 1st of January. How will parents visit? I assume there's no visa for short-term stay, or is it?
It depends where the parents are from. So if they're EU parents, the system for after the UK exits on the 31st or exits the transition period, for EU EEA Swiss citizens, it will be you can visit the UK for up to 6 months. You come in through the E gates. So if this person's parents are EU citizens and they just want to visit the UK for under 6 months, they don't need to apply for any visa. If the parents are from a country which requires you to apply for a visa before you come to the UK, then they could apply for a visit visa, or if they're coming if this person wants them to come and live in the UK, then they may qualify under the dependent parent route for family reunion. So it sort of depends on the parent's nationality and how long they really want to come to the UK for. But if it's EU parents who are just coming to visit, they do not need a visa to visit the UK even after the end of December.
Some good news there.
Indeed.
Another anonymous question here on Zoom. Do stepchildren get the status of their birth parent or their step parent if the step parent has settled status and the birth parent has pre-settled status? Do we know the answer? It's very complicated.
Yeah, so there's a rule in the settlement scheme that says that children, when you look at a child who's under 21, if either of the parents has settled status, the child will get settled status themselves. But the definition of a child doesn't include a stepchild. So in that situation, off the top of my head, the child is going to get the same status as the biological parent.
Thank you for that. A couple of questions on criminal offenses. Actually, there's one clarification question. Does this mean something like trivial, like trespassing or not having a train ticket? Could the Home Office decide to deport us or decide to withdraw a visa based on that?
Yeah, the general answer to that question is no. So the rules. The rules will change after the end of the transition period, but at the moment, the rules on the UK deporting EU citizens is based on the Free Movement Directive, which means that the UK has to show that there is a sufficient threat from the person because of their criminal offending. So it's quite a high threshold, and so someone applying to the settlement scheme who's got a trespassing conviction should not have any issue as long as that's in isolation. If you have lots and lots of trespassing put together, then sometimes the Home Office will say, well, you're not learning your lesson. But in general, and train tickets, no, not for not holding a train ticket, there shouldn't be an issue.
Next one from Hedvig here. I presume it also refers to keeping your settled status, which, as you said, you can live up to 5 years with settled status, how long does a person need to be back in the UK to safeguard their settled status? Is a one-day trip enough, or does it have to be a longer time as resident?
Yeah, it's a really good question, and it's one that I'm trying to sort of dig a little deeper into the answer. My reading of it in the withdrawal agreement, which is what this is based on, is it's the same thing. As long as you step inside the UK for a day within those 5 years, then it resets. So it's something to keep an eye on, because I think that there may need to be a confirmation of this, but it seems to be written that way in the rules, and the Home Office seems to have written their rules in the same way. So that's how I understand it. It's not about coming back to live in the UK within the 5 years. That's not how it reads.
Thank you for that. There's some questions about students. For instance, this one, I think there's, usually you need to know more detail about those cases, but this one says, will I be able to study at university as a home student and have government support with settled status?
Yeah, so I mean, the broad answer to that question is yes. You can never be 100%, because it does depend on, sometimes it sort of depends on the person's situation immediately before they start studying. But the broad answer is for student finance, you have to have indefinite leave to remain, which is settled status. And by all accounts, I'm sure in that situation, home fees apply. But I think there was a helpful link put in by someone earlier about the 3million's got a page on student fees and so on, and so you can have a look at that. But the broad answer to the question is yes, it should be fine.
Thank you for that. Yes, there are some useful links from some guidance from Universities UK and other questions on students, so you can have a look at that. There's a question here about the absences here. So I think 183 days, perhaps it was one on citizenship, is not clear from the question. So it says 183 days is the number of days one can be outside the UK and still be considered a resident. Is this per calendar year or fiscal year, or is it a rolling year? How do you calculate?
So it's written in the rules that applies to the settlement scheme. It's written as a rolling year. So it would be like any 12-month period. If you exceed 6 months, there is probably a disagreement at a legal level. It certainly seems that might not be the right way of interpreting it, but that's how it's written into the rules at the moment. And so the Home Office will base their decision on how they've written the rules, unless they're forced to change the rules in the future. So you need to work on the assumption that it's like a rolling period. And it's not just January to January or something like that. But it's a bit, I can tell you that it's an area where there's disagreement. But the rule is rolling. So if you want to meet the rules, that's the way to assess it.
Still some areas where there's a different interpretation.
Well, yeah, unfortunately, so there's quite a few areas where there's some disagreement.
There's one question, I think that's like a bit more subjective, but it says, I'm planning to apply for the EU settlement scheme for my elderly parents as dependents. Is this complicated? I mean, I guess that's your experience.
No, it's a good question. So the answer to that is that obviously, again, if we're talking about parents who are here in the UK today, if they're European citizens themselves, then they just apply in their own right. They don't need to be sponsored. If we're looking at today, if it's the future, or if they're non-European parents, then yes, they do need to be sponsored. Or after the 1st of January, if they don't live here, then yes, they would need to be sponsored. Something to be very, very aware of with these applications is, at the moment, the Home Office rules say that if you apply to sponsor your dependent parents, then we assume that they are dependent on you. And what they mean by that is, we're not going to ask you for any evidence of them being dependent on you. So it can be quite straightforward now to apply, as long as you have your birth certificate, etc. From the 1st of July next year, 1st of July 21, if you want to sponsor your dependent parents to come and join you under the scheme, then you will have to prove that they are dependent on you. So you will be asked to show that actually they are either financially or they are, for health reasons, dependent on you. So then it is complicated, and then you do have a situation where you have to prove it. But today, if you're applying, then generally it would be done using your birth certificate and your parents' passports, and so it's a much more straightforward application if you did it today.
Okay, question from Anna. I'll take 3 more questions because we actually have a different event later on.
Oh God, I'm sorry. Okay, well,
no, that's fine. It's that's absolutely fine. But there will always be like more questions. So like obviously for those, if you feel your question wasn't answered, feel free to email the Young Europeans email address, and we'll be able to like signpost you to different organizations who will answer that, because there are a lot of people who are taking EU settlement scheme questions, or I can point you to different resources, because I see a lot of questions here still about the absences, about COVID absences. And of course, Chris covered this in his presentation. So you can look back at the video, see if your question was answered, because I'm not actually sure which one was answered on absences. But there's a question, interesting question from Anna here. If you're absent from the UK under an employment contract from a British company that deploys you abroad, would that affect your continuous residency? Is there any answer for this very specific, unique situation?
So again, you'll have up to a year of posting abroad without breaking the continuous residence, because actually working abroad was one of those good reasons. So if you leave for more than 6 months but less than 12, then you'd be fine to come back in and you wouldn't break your continuous residence. If you're being posted abroad from a more indefinite period, then there's a special set of rules which says if you've worked in the UK for 3 years and then you're posted abroad, but you retain your home in the UK and you travel back, roughly speaking, once a week, and you essentially maintain your home in the UK, then you can still have settled status on that basis. If you've been here for essentially, if you are not completed a 5-year period, you get posted abroad and you don't come back, and your posting goes on for a couple of years, then you won't be qualified. You're not covered essentially by the withdrawal agreement, and so you lose your ability to qualify for settled status in the future. So there's a bit more to your situation you'd need to understand. But those are the kind of 3 situations that I would see immediately if someone says that's what's happening to me.
Okay, moving on to the next one. So there's like some questions again. So some questions saying, do I have to enter the UK before 31st of December 2020 to be covered? Yes, Chris mentioned this. So there are a few questions. You don't need to be here before this end of transition. But there's another one on absences, which is perhaps a different angle to it. Does traveling a few days every 2 weeks or every month outside the UK, when this adds up to more than 6 months within a year overall, so very short trips adding up to more than 6 months, make one lose the pre-settled status?
Well, I mean, it breaks your continuous residence. I mean, as I've said to you before, you wouldn't lose the pre-settled status because you have 2 years of absences, and in that situation, you're not being absent for more than 2 years. But you're going to lose the ability to convert pre-settled status into settled status if you have multiple trips that add up to more than 6 months outside the UK in a 12-month period. Yeah, it would. You're just not going to be able to get settled status at the end of your 5 years.
One on like more complex cases as well. Like I have an exclusion order dated 1999. Will this affect my stay in the UK?
Yeah, I saw that one. I mean that one is. I mean because criminality issues are so complicated, there's no way that we can answer that in a session like this. But the answer is having an exclusion decision, if it is serious, and it certainly would potentially lead to refusal under the scheme. So that person really needs to speak to a lawyer on a one-to-one basis to explain the background of that, and then get the full advice, because it's such a complicated area.
There are some questions that are quite long questions with like, quite detailed situations. So I will ask a last question before we wrap up the session. Like, where could people find free legal advice and support on the settlement scheme? Where should they go if they have more questions on this or more complex cases? Yeah,
I mean, so at the end of the presentation, there was a link to what are called the grant-funded organisations. So the Home Office has provided some funding to charities and local authorities to assist what they deem as vulnerable citizens to apply to the scheme for free. And so that is a place where some people can get free help. I mean, as you can see, it sort of requires them to be considered to be vulnerable, which may not cover everyone. So that's one area of support. As I say, I'm sure the 3 million can signpost people onwards to other organisations. There are a number of legal organisations who do not who will provide free legal advice to the scheme. There's always a capacity issue in this field of free legal advice. I'm sure it's just the reality is that people can't always, people are very busy trying to help people. But there are organisations out there who can assist, and hopefully we'll be able to signpost people onto one of them if they have an issue.
Well, thank you very much, Chris, for the presentation and going through. We went to almost 20 questions live, so that's a record in a short session. So if others have other questions or unanswered questions, if you rewatch the presentation, haven't found your answer, you can contact in the first instance the Young Europeans email address that the volunteers put on the chat, and we'll be able to signpost you to at least offer you a list of different organizations. We will also be publishing some answers to those questions in our FAQ tool on our website. So I'm not sure if this is yet, yes, Antonia put on the chat now on Zoom, and perhaps someone can put it on Facebook, the link to an FAQ about the EU settlement scheme on our website, and we'll keep on refreshing those pages and adding more questions as we go. So I'm just going to put all the people who spoke today together on the screen again, and just say two things to end the session with. So obviously, thank you everyone for asking your questions and being engaged on this topic. And if you found your answers today, also I encourage you to make sure that your EU citizen and family members, friends, colleagues, and neighbors are also informed, so you can share this link to this Facebook live stream and perhaps share some of the resources you found about today with them as well, because there's still a lot more outreach work to be done within EU citizens communities in the UK. So thank you to the volunteers, the Young European volunteers, James and Maria, who spoke today on the panel, and of course to Chris for providing all those answers to your many questions today. And I also like to thank the volunteers, the Young European volunteers, who post different messages and respond to some of the questions on the chat. Lara, Jay, Antonia, and Shukri, who are very busy with all those questions. And finally, just before we finish this session, tomorrow the Young Europeans Network will have another event at 8 p.m. We'll do our social event, our Christmas social event, which is a Life in the UK quiz. So if you're someone who's preparing for citizenship, you'll actually have a chance to get a fun pub quiz with actual real life in the UK questions. So the volunteers will post this on the chat and on the Facebook comments, so you can sign up via Zoom and get ready for a pub quiz on Zoom on Life in the UK questions. So thank you again to the EU delegation, to Chris Benn from Seraphus, James and Maria for this session today. And yes, everyone, please have a nice evening and continue following the 3 Millions updates for more events like this in collaboration with many other organizations. So have a good evening, everyone. Bye.
Thank you for inviting me, Liz.
Bye.
Bye.